Hi everyone. So in today's lecture, we'll be talking about different constitutional amendments, and we will see how these amendments affect the digital forensics. First, let's read out the Fourth Amendment, which states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by the oath or affirmation and particularity describing the place to be searched and the person or the thing to be seized. So given this definition, let's divide this amendment into different sub-points and see how these points affect the digital forensics. So generally speaking, the Fourth Amendment is about giving the right to the people that they should not be searched or seized by the law enforcement agencies without having a proper warrant from a court. So the two key phrases here are, the first is the unreasonable search and seizures. So the question is that who can perform these the search and seizure processes? And the answer to that is that the amendment only allows the law enforcement agencies like your police, your FBI, your CIA, and so on to conduct these searches and seizures. In some cases, if these law enforcement agencies hire some private detectives or some third parties to do their work, those parties will also be able to, or they will also have the right to do search and seizure on their behalf. So this clearly states that, like the general public, for example, you, me, or somebody else, we don't have the right to search anybody or to seize the property from any person. The second key phrase here is the probable cause. So in order to get any warrant from a judge to search an area, the law enforcement agencies need to provide the judge with a warrant, with a probable cause. So in the probable cause, they have to tell the judge that, hey, sir, we see that this particular person might be involved in this crime. Here is the evidence that, we think that will support our claim. So based on our suspicion, please issue us a warrant to search his house. And we are looking for, this particular thing in the house. So the idea here is that, in order to get any warrant, first you will have to present the probable cause. So it is not possible for a law enforcement, agent to just go into somebody's house and then if they find something illegal there, they, seize that and then present it in the court. So all the equipment or things that you find at any suspect on any suspect, if they are not done according to the law, if they are not collected while using a warrant, they will be not admissible. They will be inadmissible in the court and they will be rejected. So let's take an example. So a man was brought to trial after an employee at a computer repair shop discovered child pornography on his computer. He tried to get the evidence disqualified as the result of an illegal search, but the judge denied his motion. So the idea is you give your computer for repair, and the person who's repairing the computer finds something illegal and he reports you to the police, and then the police presents that evidence to the court that, hey, we found child pornography on this person X computer. So the idea for, or the reason for the court to dismiss this claim is that this search was not done by the law enforcement agency, as we mentioned, as a key phrase in the previous slide, that all the searches by the law enforcement agency or the people that they hire or they contact are protected by the Fourth Amendment. This search was done by the worker who's working on the repair shop. So since the worker is not part of law enforcement agency, any search that they perform is admissible and they, this case can still go on. So next, like we talk about, in order to do search of or seizure of any property, you need to get a warrant. But let's talk about what's the process of searching or like seizing any material in the physical domain, and how in the physical domain cases, and how we do when we are talking about the digital forensic cases. So first, in the physical domain search and seizure, what happens is that the investigator requests for a search warrant from the court, and the for in order to do that, the investigator has to present to the court some evidences or preliminary, you can say, results to justify the probable cause. by looking at those evidences, if the judge feels that there is an need for, like issuing a warrant, they will issue a warrant. Upon receiving the warrant, the investigator will go to the location at which they want to perform the search, and they will right off start examining the materials and looking for the forensic artifacts or evidences there. On the other hand, in the digital domain, the first few steps are the same. First, you will have to get a warrant in order to, like search or seize any equipment from any person. For the location, that is, kind of also part of the probable cause, that you have to tell which location you want to search and what items you want to search. So for the location, in our case, it will not be, say, like a bedroom or something like that, house of a person or car of a person. We will say that, like we want to search their computers or their laptops or their tablets. So you will talk about the materials or the devices that the person has. Similarly, the things that we are looking for, we will also have to give some basic detail to the judge. So, for example, if you are investigating an email extortion case, so you will present the judge that we want to investigate or do an analysis on this person's computer, and we feel that it will have evidence of extorted emails or the evidence that this person sent extortion emails to our client or to some other person. Next, let's talk about the Fifth Amendment. So the Fifth Amendment basically protects several rights of an accused. The first right is that nobody can be charged without due process. So in order to charge anybody or to, give some sentence to anyone, there has to be a due process. There has to be a complaint filed against them, either by the local people or by the law enforcement agencies. There should be proper investigation done, and after the investigation, there should be a proper trial before anybody is found guilty and charged with the crimes. The second thing is that the Fifth Amendment also protects the right of the accused to remain silent. So this is something that, you see a lot of the time in movies as well. Whenever the police officers arrest somebody, they tell them that you have the right to remain silent. So the idea is that the police cannot intimidate or pressure the accused into saying something that can be used against them. So, for example, the police cannot, force you or put pressure on you to testify against yourself and say that, hey, yes, I committed this crime. And the last thing that it protects is that it prevents putting people on the same trial more than once for the same crime. So if you committed a crime, you will get punished for that crime only once, and the law enforcement agency cannot, have two different cases for the same crime, and they cannot prosecute you twice. So, how does it affect the digital forensic? The basic idea or the basic, the most important thing here is the right to remain silent. So we will see how this affects in the digital domain. So in the physical domain, anybody or any accused, the police cannot pressure them to say or to testify whether they committed a crime or not. But when it comes to digital domain, we have sometimes information that is like private to us, and that can guard our secrets or our data as well. One such example is the password protection. So you can have password protection on your laptop, you can have password protection on your mobile phones, or you could also have some encrypted files on your devices as well. So does the police have the right to ask the person to reveal their password? And the answer is generally no. The police cannot, force anybody to reveal the password because that will go against the Fifth Amendment. So here, in this particular case of the password, there is no black and white, because anything in the law can be interpreted differently, and there have been some cases in which the password protection was protected by the Fifth Amendment. And in those cases, the judge ruled that, they just stick with the definition of the Fifth Amendment and said that the police cannot force anyone to reveal the password. There were some other cases in which the judges ruled that the password is some information that It's nothing, like you are not, you can say, testifying against yourself. You are giving just, this is a piece of information that or a key that that will unlock a room, and then it is up to the law enforcement agencies what they find inside the room. So similarly, the password is something that protects your laptop or your mobile phone. And if you reveal the password, then still there are a lot of things that the law enforcement agency has to look into. So for the Fifth Amendment, again, it's like 50-50. Some cases, they go with the Fifth Amendment and say password protection is protected. Some other courts, they say it is not protected. So another thing that affects this is also state laws. So depending on the state and depending upon the nature of each case, this can vary from one case to another. So the next thing that comes in mind is that, password is not only all the time information, say numbers or patterns that, nowadays we use other forms of authentication as well, such as biometric authentications, your fingerprints, your facial recognition, and so on. So will they be considered, or will they be protected under the Fifth Amendment? That's the other question that comes in your mind. So in that case too, like some courts said that, facial recognition or the fingerprints, they lie under the Fifth Amendment and they cannot be, like nobody should be forced to give the fingerprints to the law enforcement agencies to unlock something. In some cases, the courts rule that these things like fingerprint prints or facial recognition or any other biometric authentication, it's not some knowledge that a person holds. It's something that you possess. For example, your face is a physical thing that you possess. It's not something or some knowledge that you know or that you can reveal. Similarly, your fingerprints are some physical thing that you possess. So it is just like any other artifact that is in the possession of somebody. They are not forcing you to reveal or to say anything to you. So, like depending on the cases, there can be instances where, like if your phone is locked, and a police officer just comes, in front of you and brings the phone in front of your face, and it will recognize your face and unlock. So again, this depends or varies from case to case, state to state. In some cases, in some courts in the past to have like allowed the police to get the fingerprints or facial recognition or passwords from the user. In some cases, it is protected by the law